Service of sworn report. No confirmation of summary suspension. Keep in mind that under the statute 11501.1, the summary suspension does not become effective until the motorist is notified, in fact, they have a right to this judicial hearing. And then the 46 days in which the suspension will kick into effect would be on the 46th day at 12:01 a.m., and that would be under 501.G. Until they're served, there is no suspension running. Now, from the defense standpoint, they then will file or should file a petition to rescind, keeping in mind that if they file a petition to rescind the statutory summary suspension, it does not stay or delay the implementation of the suspension. So they go into court and they ask for continuance. If they don't proceed on it right away, the suspension, in fact, is going to continue to run. So they raise that issue. The defense attorney raises that issue. As a state's attorney, you say no. That is incumbent upon the motorist to begin the process. And as long as the delay has not been effectuated or caused by the state, then the defense, that suspension is going to stay in effect. And it is not incumbent upon the state's attorney, once that occurs, to do anything on it, as long as it is the time is attributable and the case is continued on the motorist of the defense. So if the defense goes in and says, Judge, I would like a stay of this suspension, I want a preliminary injunction so we can deal with this later, the court cannot delay that suspension. That's a statutory summary suspension, is a function of the Secretary of State. On the other hand, the motorist is served with a copy of a notice of summary suspension. That triggers the time in which the motorist should then file a petition to rescind. If they file the petition to rescind in a timely manner within 90 days upon service, and the Secretary of State does not confirm that notice, for whatever reason, the paperwork gets lost by the police officer, by the clerk, by the Secretary of State, and the motorist has protected their interests, when they come into court and they say, Your Honor, we have not had a hearing within our time, there is no confirmation, there's nothing as a prosecutor you can do. Because under People v. Madden and People v. Fitterer, the law is clear that if the Secretary of State does not confirm on that notice of suspension, it would be used as a basis to, in fact, for a rescission. Again, nothing from a prosecutor's standpoint can you do. Also, if for some reason on the first court date the motorist comes in and says, Judge, we have been served with a copy of the statutory summary suspension notice, we want a hearing. The court looks in the court file and says, well, there's no confirmation from the Secretary of State that says on what date it will go into effect. From the defense standpoint, the defendant says, Judge, we have a right to a hearing. The prosecutor would be best to give them that hearing, because under People v. Moreland, the fact that there is no confirmation in the court file does not delay the right to the motorist having a hearing within 30 days under People v. Traynor. And the hearing then should be set. The hearing is set, excuse me, if the hearing is set, they get to court, and again, there's no confirmation in the court file, then under Madden and Fitter, the case, the suspension should be, in fact, lifted. Keep in mind, from the prosecutor's standpoint, the fact that you may lose or you may have to concede on a petition to rescind does not damage your case in any way, shape, or form. And if the defense attorney, once a defense attorney comes in and says, well, now I won the statutory summary suspension, now I can win the DUI, you should concede. No. From a prosecutor's standpoint, you tell them, no, they're completely separate proceedings. They are completely separate burdens of proof. Too bad, too sad.